Welcome back to another exciting panel at the McCarthy Institute Symposium 2013. This panel is going to address a variety of issues on internet intermediary liability and responsibility and best practices. And it's going to be moderated by Will Rava, a partner in the Seattle office of Perkins Coie. And we're really grateful to have him here. He'll introduce the speakers in a moment. I did want to just say one thing about your name tag. They pull apart, and when they do pull apart, there is a flash drive with all of the content and speaker presentations that we have been able to get and provide. So you can take it home, put it in your computer, upload it, and then violate people's intellectual property rights. So it's all there, very easy to do. So, Will, take it away.
Thank you, David, and I hope everyone had a good coffee. I don't think you're going to need that for what I hope will be a lively conversation with my superb panel and you about combating online infringement and allocating responsibility for that infringement. I invite you to review and admire my panel's bios that are in your program today. They are each distinguished, credentialed, and experienced and leaders in the field. We are privileged to have them here, and I am humbled to share a stage with them or be close to the stage with them anyhow. Here's how we're going to proceed. I'm going to begin with a very short Cliff Note version of the legal landscape. Then Fred Fellman from Mark Monitor will help us by scoping the problem. Next, Elizabeth Valentina from Fox will provide a brand owner's perspective on the problem. Then Terry Chen from Google, and on the end, will provide a platform perspective. And our host, Russ Pangborn from Microsoft, is going to bat panel cleanup here, wearing his platform hat at least most of the time. Again, we hope it'll be a lively discussion. We plan to leave time at the end for questions, but I welcome you to get up and go to a microphone, which I think there's at least still one over there, or just stand up or raise your hand and interrupt with questions if you've got them. The question today is, when can or should an online intermediary be liable for a user's infringement? For shorthand, I think all of us here will be talking about platforms, which will include search, app stores, marketplace, social media ISPs, clouds, payment processors even, probably many others that I didn't mention, and many others that I guess for our purposes maybe we haven't thought of even yet. And for the most part, we're talking about theories of secondary liability, not direct liability. So under what circumstances are or should you be liable for the infringement that you allow? And in looking for an answer to that question today, I'm going to ask all of us to assume for the next hour or 75 minutes, if we've got it, that there's no real likelihood of international norm setting in this space. We can't expect the U.S. Congress to provide an answer to us, at least anytime soon. So that instead, any answer is going to have to come from the marketplace. And that's who we've got here, representatives of the marketplace. So we're going to set aside a debate about the efficacy and the need even for a top-down answer, and we're going to attempt to build an answer ourselves. So on to my brief, as I say, Cliff Note version of where we are in the law. Contributory infringement has its origins in tort and common law. In the mid-1940s, 1946, there was a case from a Massachusetts court that articulated the standard in classic form. What would a reasonable man do? In that case, Coke versus Snowcrest, the question was, would a reasonable man have stopped selling Polar Cola to bars in the Boston area because some of those bars were known to pour Polar Cola instead of Coca-Cola when a customer ordered a rum and Coke? So, again, classical tort-based articulation of the standard, reasonableness. Jump forward to 1982, where the Supreme Court considered whether a generic drug manufacturer should be liable for infringement by pharmacists who use the generic drug but then slap on a branded label. And in that court, the Supreme Court articulated the test as whether there was they intentionally induced, the manufacturers intentionally induced, or continued to supply a product knowing or with reason to know that someone downstream is infringing. So again, a no reason to know standard, classic tort common law language that we're accustomed to. Now spring forward again, 10 or 15 years to the 90s, and you have courts in the 7th and 9th Circuit, the 7th in 1992 with Hard Rock and the 9th in 96 with Fonavisa, applying the Inwood standard to the flea market or swap meet context. Whether or not the meat organizers or the flea market organizers ought to be liable for the infringement of the vendors, and both applied a similar standard. They both basically expanded the Inwood standard from products to services with a know or should have known standard. And they said you can't disregard blatant infringement. Willful blindness, is essentially actual knowledge. All right, now we're going to jump forward to the digital age. 2010 with a case that I'm sure you're all quite familiar with. Tiffany versus eBay. And this is a digital swap, of course, on a scale totally different from anything that the courts considered in Fonavisa or the Hard Rock case. eBay, according to the case, had millions of posts of new things for sale, used items every day. They had 4,000 people in their trust and safety department, 200 working on counterfeiting alone. They had a proprietary fraud engine, a Vero program, and much, much more. But nonetheless, Tiffany claims that between 04 and 05, when they did their buying program, 75% of Tiffany products for purchase on eBay were fake. And so the court there, although they were citing and discussing Inwood, stated that generalized knowledge or having reason to know was not enough. Instead, liability would have to come only where there was, quote, contemporaneous knowledge of which particular listings are infringing. They were looking for something specific and actionable, which for some people is a departure from the Inwood standard. Of course, the court said it was weighing policy issues, and it was attempting to create an adequate incentives for platforms to avoid harm while not unduly inhibiting, of course, legitimate commerce. There have been some post-Tiffany decisions. You all are probably familiar with the Louis Vuitton's big win from many millions of dollars in the 9th Circuit against a web host on a contributory liability opinion, and there have been others, and there's been loads of thinking and writing on the topic as well. People have asked whether or not the Tiffany court got it right, why or why not. They've debated whether or not there should be a notice and takedown regime, similar to DMCA, for example. They've wondered whether or not there's room for an 80-20 solution, a solution like the UDRP that's going to deal with the easy cases in an organized and efficient manner. There's been lots of scholarship and lots of hand-wringing on this topic. So that's the legal landscape, and we're focused today on how the market is addressing the question, and we're going to talk about a lot of issues. Knowledge and control, what is effective notice, technology and its role, who is the least cost avoider, how are the burdens allocated in the marketplace, and does that allocation best serve trademark policies? That's what we're going to do, and we're going to start off with Fred Fellman from Mark Monitor. Take it away, Fred.
Thanks, Will. And boy, that's a loud microphone. So first of all, I'm the only non-lawyer on the panel and probably in the room, so give me a little break. I won't be speaking any legal terms, at least too many. So first of all, one of the problems that are plaguing a lot of folks who are selling goods online is the thing that's called a rogue website. And these rogue websites are e-commerce sites that are not hosted by the brand, not hosted by one of these commerce platforms that we know of very well. They're just independent websites, and they're selling counterfeit goods. And in some cases, there are thousands of them. One of our clients actually has, I think, 11,000 incidences of these rogue websites. They're actually selling their goods as counterfeits online. And we invoked last year, we embarked on the study last year, which ended at, I think, in November of last year. And it was 9 months. We used 800 servers. We crawled the internet. We looked at 800 brands and about 1 million websites that were selling counterfeit goods. And we came up with some statistics by actually crawling those sites, picking apart the listings, and declaring them counterfeit or not, and actually aggregating the results of this. And then we did this other trick, which is in a partnership with this company called Nielsen, which you may have heard of, that has this thing called Net Ratings. And they have a panel of 300,000 folks worldwide who they look at their surfing patterns. So we've collected all of this information, and I can tell you a little bit about the problem that brands are facing. And it's profound, and it's changing. One of the intermediaries in this world are registrars and registries, and oftentimes counterfeit sites actually integrate a brand name and the domain name, and that's cyber squatting. And the biggest pattern over probably the last 10 years is that there were a lot of cyber squatted sites. And I'd say that amongst these sites, that fewer and fewer of them are cyber squatted. So it's actually harder and harder to use things like administrative procedures like UDRP to remove these sites, because they aren't cyber squatting. About only 15% of them are cyber squatted. And as you can see on the right, actually the sites are getting pretty professional. I saw some pretty profound ones. I was at the American Apparel and Footwear Association meeting in Las Vegas last week, and we saw some sites that some of the brand holders like True Religion's jeans showed that were crazily precise in terms of how they were constructed, and they looked just like sites that you might shop on. And one of the other tactics that's occurring, and pardon me for looking behind my back, is that these sites aren't using the tactic where, oh, it's a tenth of the price for a counterfeit good. A lot of times these sites are actually selling goods that are at plausible discount rates in sale periods. So they're about 40% of the sites that we looked at were discounts of 50% or less. So it might be like what you see at the end of a season. So very easy to fool users as they're patrolling these sites. In addition to that, there's, and I'm not sure where I'm supposed to be pointing. So is it up here? Right there. There we go. So in addition to that, they're also targeting consumers rather precisely. For example, we noted that there were 30 or 40 different currencies that these goods were available in, and predominantly U.S. dollars, but a good smattering of euro, pounds, Taiwanese dollars, Japanese yen, and so on. And so a very good mix of the different currencies that were in fact available. And one of the questions that a lot of people have, and this is where the Nielsen data came in handy, which is where is this traffic coming from? So we started to look at the intermediaries that were participating in this process of driving traffic to these sites. And about 63% of the traffic in total was driven by search engines and by blogs and others that are driving it. Interesting to us, though, was about 37% of the sites actually were bookmarked, and people were navigating to them directly or typing those sites in. So clearly they'd visited them before. One thing that we commonly hear from folks who are brand owners is the people who are going to counterfeit sites aren't my customers. And that was the other thing that we wanted to sort of debunk for our customers and for the community in general as we embarked in this survey. So what we did is we looked at the demographics of the shoppers that were visiting counterfeit sites. And graphs show on the left, if I recall correctly, the legitimate sites, and on the right, the rogue sites. And if you see relative symmetry across the graphs, that means that there's some similarity in the audiences, and you can see, a lot of similarity between the audiences in terms of their age group, their ethnic diversity, as well as their income and their education. So really, the same customers that are shopping legitimate sites are also shopping on illegitimate sites. So that's kind of a concern. And then the other thing to think about is how are people getting to these sites? And I told you that we're looking at the referral sites. We're also looking at the referral keywords in the case of search, which I think is kind of important in this case. And a lot of times we hear that the people who are looking for goods online and use, they're looking for counterfeits explicitly. And it's simply not the case. Cheap and discount were used by the people who are shopping both types of sites. And a lot of times they're looking for things like outlets and other sort of words that would indicate they're looking for a deal. And then a small percentage actually of the shoppers were looking for fake and counterfeit. And other words that might indicate that they knew that they were shopping for this. And it turned out that of the shoppers who were visiting these sites, 20 to 1 were looking for discounts versus 1 that was looking for a fake. And then we term these guys as bargain shoppers. These are the guys who are looking for a great deal. Of those, 1 in 5 visited the counterfeit sites, and of those, 1 in 6 actually went to the shopping cart. So there's a significant amount of traffic that's being driven. A significant amount of this traffic is being driven illicitly to counterfeit sites, and people are actually walking out the door. And we figured that's kind of hard to visualize, so we created this little ant drawing of all the folks marching to these counterfeit sites. But at the end of the day, people are actually purchasing, and that was indicative by the Nielsen data. And I always wondered to myself, who signs up for Nielsen and agrees to be watched and then goes to a counterfeit site? But apparently they do. There's no shame in Nielsen land. But lastly, these sites are professionally produced. They look really terrific. They're offering plausible discounts. The shoppers who visit the sites actually are pretty serious shoppers. In fact, they're going to 2.5 more sites, and they're spending 2 times more time shopping than the folks who just go to legitimate sites. So when we talk about intermediaries, one of the interesting things to note is that these sites actually are clustered, and they have some bit of their DNA that actually ties them together. And in some cases, the clustering is pretty profound. And this is a diagram of several thousand sites for one of our clients. It's anonymized. And it shows how this clustering for the top 10 clusters helps us identify and take down a lot of sites at once. So the reason why this is important is if you're going to an intermediary like a payment processor, or if you're going to an ISP, or if you're embarking in a lawsuit, if you have this clustering, you're able to actually remove the sites a little more effectively. And one of the tools that our clients are using pretty successfully is this case, which was Polo and North Face, who sued this group of defendants called Fujian, which were actually in the Fujian province of China, I guess, and well, at least they think they are. What they did is they did email service, and they were able to sort of group them as John Doe's, and were able to actually prosecute this lawsuit. And we're seeing dozens and dozens of these lawsuits, bringing down thousands and thousands of counterfeit sites using this leverage. And it's pretty interesting. It's been pretty successful. This is a diagram of 11,000 sites and how we're taking them down sort of progressively. It's just short of 11,000 sites. And the first lawsuit, which didn't use technology, brought down a couple hundred. The second lawsuit, which was an addendum to the one, brought down nearly 2,000. The next one, the next addendum, we're expecting to bring down another 4,000 sites. And that's how you can use leverage to bring down a big problem very quickly in the form of rogue sites. But there are lots of other ways to counterfeit and lots of other ways to look at this problem, but that's one of the ways that goods companies are looking at the problem.
Thanks, Fred. Elizabeth is now going to give us a brand owner's perspective on the problem.
I just want to stand so that I can see my slide. And here. Basically, I'm going to give you an overview of the roles that intermediaries play in providing services to sites that sell counterfeit goods or sell or provide access to pirated movies or television shows. So we created this little chart to sort of give a broad overview of the main intermediaries that participate in providing these services. So we have ad networks, payment processors, search engines. We have ISPs that act as hosting providers or access providers. And we have domain name registrars and registries. I'm not going to say a whole lot about those because I think Fred covered it. I will mention one thing, and that is that domain names have also now become a valuable asset that can be seized in the context of litigation, or in particular in criminal proceedings. And we've seen that in cases that ICE has pursued against sites that sell counterfeit goods or stream pirated movies. Moving to ad networks. It used to be that you could find legitimate businesses being advertised on rogue sites. And that's because ad networks were placing their ads for them, and legitimate businesses didn't always know where their ads were going. And this can be big business for some sites that provide access to pirated content. Now, of course, companies like Netflix will make sure this doesn't happen. In particular, because if you look at the numbers, you could have a very unpopular site and the operator could still make about $24,000 a year off advertising alone. A much more popular site, let's say the 500th most popular site, they could be making over $2.5 million a year. In fact, in one of our litigations, the studio litigations against a site called IsoHunt, it's a torrent site. It basically provides a storefront for access to torrent files that allow you to download movies and television content. And we discovered that this one operator behind this business was making over $100,000 a month in advertising alone in its heyday. And speaking of money, we have the payment processors. So for the businesses that are charging money for counterfeit goods, or in this case, software that allows you to circumvent content protection measures on DVDs or Blu-ray discs. And sometimes there are subscription fees that are paid to allow users to have access to pirated movies and TV shows. And these transactions happen because you've got the payment processors processing the payments. And also, quite frankly, they provide an air of legitimacy to the business. So if a consumer is at a site and they see Visa, MasterCard, American Express, they think this may well be a legitimate transaction. You'll notice that PayPal is not represented here. I will say just anecdotally, we have seen that PayPal is one of the payment processors that has become concerned about supporting illegal businesses and has taken some of its own steps to distance itself from doing so. And for instance, speaking of making a lot of money, you may be familiar with Mega Upload, which was a notorious cyberlocker site that hosted pirated content. And there, the operator made over $150 million in subscription revenues. And of course, none of those payments could be processed if payment processors weren't providing those services. So just pulling back for a second here and looking at search engines and the role that search engines play in helping people find and access what may be counterfeit goods or pirated sites. So we did a little search here. We typed in Life of Pi, and we started to type in FR, and we got some helpful suggestions. You could search free online, free download, free. And then looking at the results, we've got pirate site, OV guide, which that link is questionable in my view, but we do have an agreement with them that they would clean up. And then we have pirate site in the top 4 results. So then I thought, well, look, okay, let me try Lincoln. So look for Lincoln, the movie, and given that both Life of Pi and Lincoln are both in theatrical release, they're clearly not available online in any authorized way. and certainly not as a torrent file. So I thought, well, let's see what we've got. These first 4 results, all notorious torrent sites. The first one, torrents.eu, came up in some of my searches. So I thought, let me check Google's transparency report and see where does it fit. How many notices has Google, for instance, received about infringing URLs at that site? So you'll see there's torrents.eu. It's the 3rd one in the results over this past month. And it has received an astounding 270,000 infringing URLs in notices just over the past month. And I thought, okay, well, let me do one more search. Argo, also in movie theaters, I assure you, not available as a torrent file in any authorized way, and again, 4 infringing sites. And I don't know if you can see from here, but the last one is, once again, torrents.eu. And we understand that Google has taken into account the number of notices a site receives as a signal as to where that site will be placed in the search rankings. However, you can see anecdotally, it's still coming up in the top results. And I can say from our own internal research, we haven't really noticed an appreciable difference. But looking at some of these sites I thought were very curious. First result, the Pirate Bay. The Pirate Bay is a notorious pirate site whose operators have been convicted of infringement in Sweden. And I know that Fred mentioned a lot of people will go directly to the site because they know the site instead of going through Google. And the Pirate Bay being a very popular site, you'd think that would be the case, but we still find that Google directs about 15 to 20% of the traffic to the Pirate Bay. And that might be because since it turned up as the first result, it's probably a really popular link, probably a really good link, not a broken link, and the cam, the unlawful camcord on the other end of that link is probably pretty good quality if a lot of people are accessing it. Third one down, ISOHunt. As I mentioned a few minutes ago, the motion picture industry sued ISOHunt, actually here in California, and currently has an injunction against them, and they're not to provide access to our titles on an ongoing basis. Moving out of the land of search engines, I wanted to look briefly at ISPs. As I mentioned, we have ISPs that act as hosting providers or access providers. In terms of being a hosting provider, these are ISPs that are obviously hosting these rogue sites. And we've, in some cases, voluntarily, when an ISP receives a referral about a particular rogue site or site selling counterfeit goods, from a rights holder, they may well choose to drop that site because they're concerned about hosting illegal movies or illegal content and being associated with that. But in other cases, we have, in Europe, been able to achieve injunctions against hosting providers to stop hosting sites like the notorious Pirate Bay. And we've been successful in Belgium, Germany, the Netherlands, Luxembourg, and Sweden. However, there is a wrinkle here. In Europe, we have a tool that allows us to get an injunction against an intermediary to require that they take steps to prevent infringements without having to establish that the actual intermediary itself is liable for the infringement. And that, of course, is a key difference between Europe and the US, where in the US, obviously, you can't get an injunction without establishing liability first, and courts are particularly reluctant, as we heard earlier, to hold an intermediary liable for the infringement that it supports. Another type of injunction we've been able to achieve, and other rights holders have as well, including the music industry, is a site blocking order. This is an order that requires an internet access provider, which is an ISP obviously providing access to the internet, to block a particular site from being accessed by their users. And again, these are notorious pirate sites like the Pirate Bay and Newsbin, and we've been successful with these site blocking orders in Austria, Belgium, Denmark, Greece, Finland, Ireland, the Netherlands, Turkey, and the UK. Hot off the presses, the British recording industry just achieved a number of orders just yesterday in the UK, ordering all the major ISPs to block a whole bunch of the torrent sites, many of which we just saw on some of the previous pages. And I'm sure, as you can imagine, that this will be very unsurprising to you. Once a block is implemented, and here's just some evidence from the block that was implemented in Belgium against the Pirate Bay, the popularity of the site goes down, obviously. In Turkey, where there was a criminal order ordering the ISPs to block a number of Turkish sites, again, you can see that the popularity tapers off. Certainly, if someone is determined, they will find a way to get around the block, but for the most part, casual users are deterred, and they're really quite effective. And that's all I have to say for my overview, and I look forward to hearing from my colleagues.
Thank you, Elizabeth. And we're going to return to the world, to, as you said, the land of search engines right now with Terry Chen from Google.
Thanks. So I think many of you are already familiar with Google's products and services, so I'm not going to spend much time introducing Google to you, other than to highlight that Google faces the counterfeit piracy problems from both a brand owner perspective as well as an intermediary platform. So as a brand owner, we obviously want to protect our assets, and my team is responsible for protecting Google and some of our other really valuable brands like YouTube and Gmail, et cetera. And I think especially as we've gotten into the hardware space in the last few years with our Nexus phones and tablets, we've been spending a lot of resources fighting the counterfeit Nexus phones, et cetera, working with customs and all of those things. As an intermediary, though, we also spend a lot of resources on ensuring that our advertising products, for instance, are not abused by bad actors, and that our removal policies are consistent with the law and good for users. And we do have removal policies for all of our platform products, but I don't have time to cover all of them here today. So I'm going to focus my comments on two areas that we seem to get a lot of questions, and that would be ads and search. So first on ads. Just a quick introduction to our two main advertising products. The first is AdWords, and this is our ad platform where advertisers can select keywords that they want their ads to be triggered on our search page and target users when they're searching for things. So Google gets paid only if a user actually clicks on the ad. So in this example, you see that the query is Toyota Prius, and ads show up on the top and right-hand side of the search results. And what we want to do, of course, is make sure that there are no ads for counterfeit products that are showing up in AdWords. The second main advertising product that we have is AdSense. And this is our product where we place ads on third-party websites, and the owners of those third-party websites can monetize their sites through the advertising. And this is an example of a blog that I read on a regular basis. I'm sure many of you in the audience do as well, and the law students, if you're not reading Eric Goldman's blog, you should be. So you can see that there's an ad on the side for a USF study abroad program, and so this is a way for the website owner to monetize their site. And with these, we of course want to make sure that we're placing ads on sites that are not engaged in illegal activities like counterfeit or piracy. So before I jump into how we fight counterfeit activity in our ads products, I want to first make a distinction between trademarks and counterfeit so that we're all on the same page. Obviously, counterfeit is based on trademark law, but in terms of our policies for our products, we treat them very differently. So our trademark policy is different from counterfeits. Trademark policy covers the use of trademarks as keywords or in an ad text for promoting genuine goods and services, and this is something we allow. That's where all the cases have been in the litigation, but we do allow keyword advertising, and it's really about promoting genuine goods and services. Our counterfeit policy is a totally different issue, and counterfeit activity is strictly prohibited from our advertising platforms. So these are ads that are promoting counterfeit goods or on counterfeit sites, and really the use of a trademark isn't even necessary there. So you could, for instance, have an ad for discount designer handbags. You never even mention a trademark. But if you're selling counterfeits, then you're not going to be allowed in our ads products. So Google spends a lot on ensuring that its ad products are free of counterfeits. We want to stop the bad ads, and we want to make sure that we're eliminating bad actors from our systems. And the reason that we do this isn't just altruism. It actually is in our business interest to make sure that our ads are secure and not being used by counterfeiters or scammers or other bad actors, because at the end of the day, we are entirely dependent on having relevant and high quality ads that the user will actually click on, since that's how we get paid. So if a user clicks on our ads and they end up on a counterfeit site and get a counterfeit product that they were really looking for the real thing, then they're going to be less likely to click on our ads the next time around. So there is a common misperception out there that Google somehow benefits from scammers and counterfeiters, and they're just another advertiser, and so in some ways shouldn't we want them, because that would be more revenue from another advertiser who's paying. And this is really pretty far from the truth. So Google is financially harmed by counterfeiters. Counterfeiters are criminal networks that they're not good advertising clients for us to have. They're usually using stolen credit cards, even secure the advertising, so we're not getting paid. And separately from that, we are spending, they're a drain on our resources. We spend tens of millions of dollars on machines, engineering resources, and teams of engineers, et cetera, to prevent the counterfeiters from getting through our systems. So they're actually really a drag on our systems. So this slide is really to illustrate some of our efforts in the ad space on making sure that counterfeit ads are not getting through the system. And we have both proactive as well as reactive efforts. So on the proactive front, as I mentioned, we put a lot of money into engineering resources, technical machine resources, and teams of folks to try to make sure that counterfeiters aren't getting through our systems. And we have both automated systems and manual review for doing that. And I think, as those of you who are in the anti-counterfeit space know, it's a really dynamic space. Counterfeiters are constantly changing tactics to try to game the system. So we always have to try to stay on our toes as well. So, one day it may be that they are doing different kinds of cloaking sorts of things with the domains. Another day it may be that they're doing things with the IP address. I mean, they're constantly changing. And I think that sometimes there's this image of it's just some snotty-nosed kid in a garage somewhere doing this, and I think that's really a fallacy, right? These are actually really organized criminal networks of folks. And so, for instance, we have computer scientists on our staff, on our end, who are dedicated to fighting counterfeit ads in our systems, and they tell us, I have my PhD in computer science, and the counterfeit rings, they have their PhDs in computer science on their side, trying to get through our system. So it's a bit of a cat and mouse game, but our engineers are developing risk models to try to catch the counterfeiters, and they're constantly updating those models. And we are actually catching the vast majority of ads through our proactive efforts before they ever make it onto the actual display page. So over 95% of the ads are actually caught actively by our systems. We also do have to rely as well on reactive efforts. So this is a copy of our complaint procedure that not only brand owners, but also if you're just a user, we want to hear from you. If you see a counterfeit ad, let us know so we can investigate and remove the ad, terminate the accounts associated with it, et cetera. And again, you don't have to be a brand owner. You can just be a user. Anybody, let us know, because we do want to know about it. So in the interest of time, I'm not actually going to show this video, but it will be available to you in the materials. It's just a short 2-minute video that we put together explaining sort of all of the different things that we're doing for the kind of risk engine and the technical efforts that the engineers are making. And here are all of our links and contact information if you do want to file a complaint or let us know. We definitely want to hear from folks about counterfeit ads that they're seeing. So turning to search. Yes. Turning to search. So Google is, I think most of you know, I'm hoping most people do use search engines, and if you do, that you're using the Google search engine. But the search index simply reflects existing content on the web. And you know, we aren't controlling or creating content. We really are just reflecting what's out there on the internet. And that can be the good, the bad, and the ugly, right? That's what's out there on the internet being created and controlled by third parties. We don't have a relationship with the owners of these pages, et cetera, which is very different from the ad side, where it's actually more of a closed system. We can do more there. We actually have a relationship with the advertisers, et cetera. But so in terms of what brand owners can do on the search side, obviously there is the DMCA, which I think rights holders have been able to use the DMCA as a really effective tool to remove pages for piracy and counterfeit from web search. We are, in some ways, spending a lot of resources. I almost feel like we're in the removal business in some ways. So right now, so last month, we removed 14 million pages from search alone. And you know, there's a lot of web pages out there. There's over 1 trillion web pages out there. And so the odds are good that there's always going to be somebody out there doing something bad with respect to making copyrighted works available or counterfeit goods or whatever. So, you know, we do our part with the DMCA. We're removing a lot. But at the end of the day, we do need we need the rights holders to let us know what are the pages that are actually infringing and let us know so that we can follow our obligations under the DMCA. In addition to the DMCA, we also have a voluntary removal policy where if a brand owner, for instance, gets a court order adjudicating content to be unlawful, then we will remove that from search. To be very clear, this court order does not need to be against Google. We don't need to be a party to the lawsuit. Go after the bad guys, get a court order just adjudicating that, you know, x.com or whatever the web page is illegal, is counterfeit or whatever. And then if you submit that to us through this court order form, we can remove it from search results as well. And that, you know, again, I think that one of the tensions that's always been there when we've talked about this at the legislative level, et cetera, is intermediaries really are not in the position to be able to do the sorts of fact-finding and adjudication, really, of what's legal or not that courts are. And so if you bring us a court order that's already adjudicated this content to be illegal, then that's something that we can enter and suppress that page from search results. Another tool that brand owners have had a lot of success in using is web spam reports. So web spam refers to websites that are attempting to violate a search engine's quality guidelines, or that otherwise, essentially they're seeking to rank higher in search results than a search engine's own objective assessment of their relevance and utility would rank them. So essentially they're using black hat SEO techniques, right, to try to rank higher. And that's something that, you know, everybody has to follow webmaster guidelines. We take ranking very seriously and we take relevance very seriously. There's over 200 signals that the algorithm is using to try to determine relevance. And if somebody is engaged in web spam, so they're, you know, creating lots of bad backlinks, very spammy types of black hat SEO techniques, then that's something that we would want to know so that we can penalize the ranking for those. And then finally, I think it's really important that brand owners, and speaking as a brand owner myself, that brand owners take responsibility and optimize their own sites to make sure that their own sites are actually ranking well in search results. And so just like in the offline world, we have to manage our reputation, you've got to do that in the online world as well. In order for your site to rank well in search results pages, obviously it's important that you're also optimizing, making sure that we can crawl and index your site correctly, et cetera. One thing that a lot of brand owners have had success with is they're actually creating content now beyond just their own homepage to educate consumers online about counterfeiting. So for example, this is a page that the Federation of Swiss Watch Industry created. It was actually a decoy website that it looks like a site that you're going to be able to buy a counterfeit watch on, and they optimized it so it was actually ranking really well in search results when people were searching for certain things like fake watches or cheap watches, whatever. And so it would come up. The person would think that they're at a real site, and they'd try to go through and purchase the watch, and at the end an educational message would come up and explain that, hey, this is counterfeit and this is why it's bad, this is why it's criminal, et cetera. And they had a lot of success with that campaign, and I think it's really good in terms of user education, but also in terms of trying to control the content that is actually out there. At the end of the day, search engines are just indexing what's out there on the web. So if you're going to have content that's relevant, it's going to come up in search results. And a lot of other major brands have told us that they've had good success with creating different educational pages, YouTube videos, or whatever that explain how to tell the difference between fake and authentic products. And so those are the things that are coming up when you're doing searches for those brands, not just their homepage, but also other content that's really about combating counterfeit. So with that, I'm very glad that I did not have to follow not only Russ, but I think he's going to be introducing Chuck Norris to you guys.
I have props. Talking props. Well, maybe I won't use this prop, but you get the idea. No, the idea is, we all know that Chuck Norris is a famous guy who earned his fame not only from his martial arts capabilities, but also through his success as an actor here in Hollywood. He even went so far as to make sure that he got a trademark on his name, Chuck Norris. And in fact, Hollywood even put in a street called Chuck Norris, but of course they had to change it, and you all know why, because nobody crosses Chuck Norris. Wah, wah, wah. Okay. The true story of that is yesterday after the studio tour, we went through the Fox the Fox store that had all of the fun gadgets, and actually came across Chuck Norris, and I realized I have to use him as part of this because this was all prepared long before we had the bobblehead. But you know you've really made it when you have your own bobblehead. The reason we're using Chuck Norris as an example is because as a platform, you do get some overly aggressive IP owners at times. And while we were hearing examples of the DMCA and how efficient it is when you have copyrighted content that needs to be taken down and the process is built in and part of the statute, in the case of trademarks and right of publicity, that's not so. And we have evolved in having platforms effectively use notice and takedown when people find infringements happening. One of the disservices that occurs, though, as you're developing these platforms, you do have some overly aggressive IP owners who try to state some claims that go a little bit too far. Microsoft, when we launched the App Store for our Windows Phone marketplace, one of the first demand letters we got for an app takedown was from Chuck Norris's lawyers. And they provided us a list of 6 apps that they wanted removed from the store. The first one was an app on 660 Chuck Norris facts. Pretty descriptive. However, Chuck Norris, being the savvy guy that he is, had his lawyers go out and register Chuck Norris Facts as a trademark. So the fact that he had the registration and that there was the likeness of Chuck Norris on this app said, makes sense, we'll take it down. Question whether or not there's a pretty good defense on an app about Chuck Norris Facts could call itself that. But they used the likeness, so we complied. The same thing occurred on the next one. An even clearer image of Chuck Norris was sitting on it, so that was removed as well. And you get the idea that a few of the apps went so far even as to act as though Chuck Norris endorsed them. So that's pretty much a no-brainer for us to remove that. But where it gets a little bit interesting is Chuck's lawyers asked us to remove an app that was called Police Badges. There was nothing on it that said Chuck Norris. There was nothing in the description about the app that actually mentioned Chuck Norris. As we did a little bit digger deeping, we found out that there was a Walker Texas Ranger badge as one of the images in the app, and we politely had to decline because Chuck Norris didn't own any trademark registrations on Walker Texas Ranger, but he tried to claim that he was so associated with the character that we should comply. That one stayed up. Chuck's lawyers also decided that it was appropriate for us to take down an app that was called Just Jokes because there was a Chuck Norris joke in there. Exactly. So, point is, when we are evolving a new online platform and we are not the first comer with the largest app store with the most apps in it, and we're trying to compete, we need to build an ecosystem that is friendly to apps developers, so they'll want to come to the platform and start building it. So if you start having the policies in place where you're going to be removing everything immediately just based on the notice in the context of something where you have overreaching trademark owners, it makes it difficult for the platform to succeed. So we wanted to use Chuck as an example for that. And much in the same way that my colleague Terry had just talked about Google in the context of both a platform and an IP owner, I've been asked to do the same thing. This is our single point of entry for anyone who has complaints about infringements on our properties. Over the past couple of years, we've been trying to get really streamlined into a single entry point to make it much easier for content owners. So as you'll see from the above, whether or not it's going to be on the search engine, whether it's going to be on our app stores, or whether it's going to be any of our online services, cloud platforms and the like, you go to this one spot and it'll walk you through the takedown process. As a pretty prominent brand owner and content owner, software company, we are very active in utilizing third-party notice and takedown as well. This is an example just for the sake of showing that we eat what we kill, so to speak. In the Apple App Store and in the Google Play App Store, we just did a quick snapshot of Skype to see what type of apps would pop up. Sure enough, all of these are infringing apps that incorporate the Skype logo. And so we've become very familiar with the online tools that are available through our competitors for doing notice and takedown. But we've taken it to another level. We have dedicated anti-piracy and anti-counterfeiting teams focused on identifying and taking down counterfeits, digital counterfeits, and piracy, pirated software. We have a program manager that has developed a heat mapping capability that can identify websites with digital copies that are infringing copies of our software globally and reflect them in virtual real time. And at any given time, we'll have as many as 28,000 websites hosting pirated software around the world. the system allows us to send out crawlers, digitally identify the counterfeits, and then allow us to target them for our own notice and takedown initiatives. This map here shows what the world heat map, according to our snapshots, looked like for hosted piracy in the range of 2008 to 2011. From the year of 2011 to 12, it turned into this. And since we had access to the fund program managers that actually do this, I said, I'm going to be in California. Can you give me a snapshot? So as of last week, looking at Silicon Valley and LA, you can see that there are a fair amount of web hosts in those regions that are hosting pirated content as well. And since I grew up down the road in Long Beach, I wanted to get even closer, so we zoomed in on the Port of Long Beach area, and I'm happy to say that the majority of those blue spots showing any kind of heat map activity are in Orange County and LA, not in Long Beach. Maybe it just means they're a little technically challenged down there, but what I wanted to do is, understanding the volume that has been increasing, we've also dialed up our own efforts. So in what we considered pretty aggressive anti-counterfeiting initiatives we had done even as far back as 2008, we have coordinated with many of our outside vendors and our own direct efforts to dial up the takedowns we've been doing significantly. You can see through our calendar year of 2012, we had hit over 20 million takedowns. And in this calendar year, in the first months of 2013, we're going at a rate of about 1.5 million takedowns in a month. And we saw earlier, whoops, I didn't do that, that the Google Transparency Report is publishing the takedown efforts that have been happening on their platforms. And Microsoft is consistently one of the top handful of takedown notice submitters in that transparency report. The interesting thing there is a lot of times you can target specific websites that will have many infringing links within them, and we've been taking down at a significant rate. And when I showed this information to Milan this morning, she was excited to note that Fox is also in the top 5 of the list too. So we've been actively enforcing our IP out there. One of the other things that I like to point out is how much we partner in the ecosystem. We have processes in place to educate law enforcement. We have been working with industry for industry best practices. Many in the audience here had worked with Microsoft and others on the user-generated content principles and continue to work on best practices. We train industry partners, whether it's in the financial world or otherwise. And we continue to enhance our technologies to identify not only where there are counterfeits, but where there are other security breaches online. Just yesterday, Pete Becker and I were at the ICANN offices having discussions with officials there because our digital crimes unit had proactively taken down a recent botnet. The botnets, for those of you who aren't familiar with them, are these crawlers that are sent out by bad guys, and they attack dormant domains, use them as a host, and send out spam. So the fraudulent lottery letters and all the spam that you get in your inbox. The last takedown we did before this, the Rustock botnet, when we took down that server and identified the bot, we were able to identify which domains were about to be attacked, take those offline in cooperation with other industry players like MarkMonitor and others, in order to take those offline. We saw what was a 1.5 billion spam email generation reduced by over 90% as a result of that takedown. And then just this last week, we took down another botnet that is identified as the Bamatol bot, and it has evolved. You know, this is the 4th time we've gone down this path of trying to take down different bots from around the world, but this particular one actually goes to dormant domains again and does the exact same thing, but it also has a fallback that's called a dynamically generated algorithm, or a DGA, that it uses as a backup to hard-coded domains, so that if the hard-coded domain goes down, it dynamically creates its own and tries to do it again. But because we were able to go and seize the servers where we identified the bot, we can reverse engineer it and identify what it's going to attack next. We then need to go and get the cooperation of ICANN, the registries that are going to be impacted, and the registrars, so that we can take these things offline. In order for us to do it, we end up eating the costs of registering literally thousands of domains to get them offline for the first month, but then we have to go and get the cooperation of the registries and registrars and ICANN to waive fees, because ultimately this is something that is acting as security for the internet. It is not something that is something that should be invoiced to Microsoft for going out and helping secure the web. One of the other things that we also launched just yesterday is something that is called the CCTLD Registry Security Assessment. And again, in the context of domains, we've been hearing it throughout. When you have folks using cyber-squatted, typo-squatted domains, a lot of times they're putting on there, people go there, click on links, and they think they're in something, and they end up getting malware downloaded to their machines. So there's a lot of security breaches here. Our security team had identified that numerous of the CCTLDs were insecure in the way they were being managed, and also had many gaps in the code. So what we did is we created this registry security assessment tool, and we're making it available for free to all of the CCTLDs to go in, scan their own registries, identify where they have any gaps or holes, and fix it themselves. So again, we're doing things on the proactive side to ensure that we're making a better and more secure web experience. And with that, turn it back to Will for some questions.
And I'd like to start by asking a question of Elizabeth and Fred, actually. You've heard now what Google and Microsoft have to say about what they're doing proactively and reactively to help solve the problem that the two of you identified. And I'm curious about your reaction to that and what you think they should be doing differently or more of.
Notice and takedown doesn't work. It's basically like emptying an ocean with a teaspoon. You may have heard that expression before. It doesn't work, and it's just one of 5 requirements under, actually more than 5, but one of many requirements under the DMCA in order to be eligible for the safe harbor. But somehow courts and the industry practice has conflated all of those into the one notice and takedown regime. It's not effective. As you can see how many notices we're sending, we're on the top, like just looking at search engines alone. We're on the top of that list and sending tens of thousands of notices every day. And sites are receiving over 300,000 notices, and they're still turning up in the top of the search results. So we're really not seeing any impact in that regard. I mean, at what point does it become knowledge or facts and circumstances from which knowledge of infringing activity is apparent that requires some expeditious activity to disable access or removal? And that is a separate requirement under the DMCA than just simply getting a notice and responding to it. So it seems to me something more has to be done. And I gave you a little bit of the framework in Europe because the idea there is that these intermediaries are best situated to take steps to prevent infringements. And that's why the Europe regime took away the requirement that you have to actually show liability to get that injunction. And it's sort of creating more of a cooperative environment between rights holders and intermediaries to do what they can given where they're placed and their role in providing services to rogue sites.
I want to give Fred a chance to answer that question, but then I'm going to go down to the end of the aisle and ask you, Russ and Terry, if you are in fact in the best position to help Elizabeth and Fred and his clients do what they need to get done.
Yeah, I'd echo a lot lot of what Elizabeth says. Our clients refer to this whole process of notice of takedown as sort of the whack-a-mole game. You might have heard that before. They feel that it's, you know, relatively a thankless task, but I mean, they still engage in it, and they use tools to do it in a way that actually makes it scale. One of the things that makes it difficult, especially I think it's something that's going to come up a little bit later, is for the small guy. You know, smaller brands, it's very difficult for them to enforce, and also the disparity of the different sort of notice and takedown systems makes it difficult. You might have a vendor like or an intermediary like Google with a lot of different pages for taking down different types of issues. I like the idea that, you know, that Russ mentioned with respect to Microsoft, and they have one page where you can take it all down. Sometimes it's a myriad of these different sites, and then you have networks of these sites. For example, some of the marketplaces are affiliated, but they each have a different site for takedown of counterfeit goods. So it becomes very difficult for folks.
Yeah. So I'll echo that actually on behalf of the small brand owners. Just a quick interlude here that with whom I work, that they struggle with this quite a bit. They have an infringing app, for example, that shows up in 3 or 4 different places. They send essentially the same notice to those 3 or 4 different places and get 3 or 4 different responses. Some take it down, some don't. Some require different information, and sometimes it goes down and comes back up again. And the frustration level, especially for a small client whose maybe singular IP asset is being infringed, is incredibly high. So, Terry and Russ, why are you or are you not in the best position to help out my clients?
Actually, Will, I think that Perkins represents Google as well. So I'm your client too.
And Microsoft.
But so I would say that actually intermediaries are doing more. We are doing way more than just notice and takedown. Certainly that tends to be a topic that is out there and that people talk about more, but we are doing so much more than just that. I mean, we went through it on Surge, on ads, as you just said. We are investing a lot of money to proactively catch the counterfeit ads before they actually even go out there. We are investing a lot in the technologies to make sure that we are not placing ads through our AdSense program on sites that are engaged in piracy, for instance, because we don't want there to be any kind of monetary reward for those kinds of sites. On YouTube, for instance, it's another one of our big platforms that I didn't have time to talk about today, but we have spent a lot of resources in developing Content ID, for instance, which is our technology where rights holders can actually identify and flag using Content ID content that they think is there for removal. So it is more than just simply a reactive notice and takedown. We absolutely are investing a lot on the proactive side. In terms of whether or not intermediaries really are in the best position, I would argue that, and as a brand owner and an intermediary, I think it's too simple to say that any one group of folks is going to be able to solve this really huge and complicated problem. I think that in some ways, what we're missing from this discussion is really attacking the source and figuring out what are the incentives for the actual bad actors. And so, like I said, there's over 1 trillion web pages out there. As long as it is profitable for those bad actors to be engaged in copyright, infringement, counterfeit, et cetera, they're going to continue to do that, regardless of what intermediaries can do or what other folks can do. I think that we really need to be attacking the source, and I think placing intermediaries in the role of being the censor, the mediator, the adjudicator, and being responsible for policing the internet isn't really, one, going to solve the problem, but two, I don't think that's in the best interest of users from a public policy standpoint. I think that, similar to, our algorithm cannot know. We're not in the best position to know. We can't know if something is infringing. We can't know if something is authorized. We can't know if something is legitimate goods or actual counterfeits. That's not something that we can tell on our own. That's something that the rights holders are in the best position to know. I certainly, as a brand owner, I wouldn't, sometimes I can't tell if Nexus phone is counterfeit or not. But separately, I mean, I certainly wouldn't expect an intermediary to be able to make those sorts of decisions. But as I said, I think that where we can do things, we are trying to do those things. But I think we need to be careful about expecting a very complicated problem to be resolved by any one by any one intermediary or player in the ecosystem. And I think that at the end of the day, it's really tough to expect. Kind of akin to the brand owners, it's hard to expect them to, especially if they're small brand owners just starting out, it's hard to expect them to do this whack-a-mole and go after each of the different apps that keep popping up, et cetera. I think at the end of the day, you have to look at the bigger picture of the ecosystem and not just the small brand owner, but also look at the small tech company that's starting out. We don't know what the internet's going to look like. We don't know what other cool apps or other things that are going to develop. And Microsoft and Google, we may be in more of a position to be able to do certain things because we're more established. But for all of those new upcoming tech companies, I think it's really tough to shift the burden of policing and solving this very complicated problem onto them, on top of them actually trying to get their technology out and develop their product, et cetera. And if we just think about, for instance, 18 months ago, Google Hangouts, I don't know if people use that, but 18 months ago it was basically a video conferencing over the web that anybody can do, and you can have lots of people on it. 18 months ago, people weren't really engaged in that. That's a new thing that was able to develop. And I think that if small tech companies had to really go out there and worry about solving this counterfeit piracy problem and policing everything, it would really kind of stifle a lot of the technological innovation that could come.
We've got about 3 minutes. I want to make sure that people have a chance to ask questions if they have them. Otherwise, I will continue to engage. So if you are going to ask questions, please looks like someone's going. So I will.
Microphone down though.
I'm sorry?
I was going to say, do we want to take that microphone down the aisle so they can use it here too?
Go ahead.
Oh, hi. I was just wondering. Oh, I'm Guy Noyes, McCarthy Student Fellow. And I was actually a little bit curious if you'd expand a little bit more on, with regard to notice and takedown, how the intermediaries are evaluating these things and how the application of notoriously difficult defenses like fair use comes into that, if it's a problem for maybe stifling, being overbroad. I think Russell talked about the Chuck Norris apps. Several of those were overreaching on the part of the rights owners. But if that's a problem in that the intermediaries shouldn't be getting into, or if they're really just filtering out the easy cases and making it so that only the difficult, controversial cases get to the courts and making it better for the court system in that regard.
It's really dependent upon the manner of the notice that's coming in. If it's DMCA and it's DMCA compliant, you take it down. This is part of the issue. Even in those scenarios, though, there have been times when you're doing DMCA takedowns where, again, an overly aggressive IP owner will give you a long list of links where they're linking to infringing content, and in the midst of it, it may be youtube.com, in addition to a bunch of others that are very specific. So you got to be really careful that it's not just going to be something that automatically then delists from your search engine YouTube. That would not be something that would be good for folks who are trying to find anything. But, when it comes to the trademark side of things, when people are making those same type of complaints, there is a little bit more of an analysis that goes into it, because you do have to look at the manner, and there are plenty of fair use alternatives that could give somebody the reason to use a specific trademark in a specific way. And that's why I use the Chuck Norris examples. It is a time-consuming and resource-consuming thing that the online platforms go through to ensure that they're trying to strike that right balance.
As do content owners.
Absolutely.
So we have to
Good content
review
owners, yes.
all of the clips and make sure that fair use is considered. That's sort of post-lens case, but it's also just good practice. And another sort of safeguard against that is the counter notice process. If someone's piece is taken down and they think that it should not have, there is a counter notice process.
Great, thank you. That answered my question.
I have a quick follow-up question for Elizabeth and Terry. Elizabeth, it seems like you teed up a situation in which there were clear counterfeit uses in, I think, a copyright and trademark sense of movies, and there just can be no justification for it. And what I heard you saying is that that knowledge is, and that continued. It continues despite the fact that the search engine has knowledge that this is going on. And that raised to me the question of why is it impossible or just not cost effective, Terry, to build into the algorithm of Google itself to screen out some of this, maybe not all of it, but to, when it reaches a certain point of a certain kind, to put it kind of on a warning list and just not allow it to come to the top of the algorithmic results. It seems doable to me in a modest way. You might not get rid of all of it, and it seems like it would be protective of brand owners and not overly burdensome on Google or Bing. So why isn't that a fair balance?
And they have, in fact, done that in France. There was a number of allo streaming sites that were the subject of litigation seeking injunctions against various intermediaries, including search engines and Google did delist those for a time. So we know it's certainly possible, but they have chosen, from what I understand, and Terry can explain better, but from what I understand, they've chosen not to. And in fact, they continue to go back and crawl these sites every 4 hours. So we just can't stay on top of the infringing URLs because you're going to get a fresh batch every 4 hours. But it does seem to me that there must be some number that gives you enough knowledge that you need to do something else, something more.
It could trigger a delisting algorithmic response. Is it not technologically feasible, or is it has its own host of other problems?
Yeah, I think there's a number of issues here, and I am probably not the best equipped on the technological engineering side. So I think that we need to think in terms of scale. So it's not like there's one person back there and there's this catalog and we can just kind of pull out, oh, this one's infringing, so we're going to take it out and we're never going to show that again. I think the thing to remember is that Google is indexing what content there is out there on the web. The content out there on the web is constantly changing, right? So it's dynamic, it's changing all the time, things are coming up, coming down, whatever. And so our algorithms, just like we've talked about today how it's very difficult to figure out if something is a counterfeit site or not. For instance, like Fred talked about, a lot of these sites look really very glossy. They don't say, hey, I'm a counterfeit site. They say, hey, come and find some discount or sale or what outlet, whatever type stuff. And just like on the copyright side, it's not always clear if something is an authorized use or not. It could be fair use, it couldn't be, it could be part of self-marketing, whatever it is. There's no way for Google to be able to know in a scalable way over 1 trillion web pages what things are infringing, what things are counterfeit, and what things aren't. And so the way that the search index works is going out there, crawling the sites, and then trying to figure out what's relevant and returning those results. That's not something that you can really just build into or make it scale. Again, with trademarks, for instance, there's a lot of generic or just common words or phrases that are being used. And so how would Google know if a particular word, so some of these, like one of the movie titles is amour. How would we scale that out and just get rid of that out of search results? Search results are just reflecting what's out there. So whatever content is being put out there on the web, we're reflecting it if it's relevant. We're not hosting it. We don't have a relationship with those sites. And again, getting it out of search results doesn't mean that you've attacked the problem, right? The source is still there. You can still go directly to that website. You can use another search engine to get that website. You can go through social networking, et cetera. So it's not really just a simple technical fix that we could actually know what's out there. As Elizabeth mentioned, we do now take into account in our algorithm how many DMCA notices a particular web page has gotten, and so that's one of over 200 different signals. But figuring out relevance and figuring out what a user wants to see in their search results is actually a very difficult and complicated process, and so it's not something that's simple. And I think also in terms of autocomplete, which is where you saw life of Pi and then Google listed what are the other searches or search queries. That's not Google suggesting that. We're not making up those queries and saying, hey, go look at these. Those are actually just reflections, again, of these are what users are searching for. These are popular search queries that other folks are, that we see over and over again, and we're reporting and reflecting that that's what's going on. So again, you have to go back to the source, attack the problem. If there's demand, there's going to be that content.
And yes, we do go to the source and we do attack the problem, but I think what we're trying to pin down here is what can intermediaries do to mitigate the role that they do play in providing access to pirated content or counterfeit goods. And I certainly think there is more. I mean, I certainly have some ideas, and I think I sort of showed some of them up there. I can tell you that there are a whole slew of movies that are not authorized to be distributed by way of torrent. So that's something that could be eliminated right there. You get 300,000 notices for one site in a month. You might want to stop crawling that site or stop crawling it as often. I do think there are things that can be done, and there are certain word combinations that could mitigate access to pirated content.
So I would just note that YouTube.com, for instance, receives millions of DMCA notices, and we actually do a lot of removals on YouTube. We wouldn't want to no longer list YouTube.com in search results.
All right, there's still a fair amount of non-infringing material on those sites. But that said, we're going to have to end it. This is a conversation that will continue, I'm certain. But it is lunchtime.
Lunch in the commissary. Thank
Lunch
you.
in the commentaries.
Thank you very much.
Thank you all.
Great. Is that the time you want?